Okay. Actually, I think we have 2 court reporters. Good afternoon. This is Magistrate Bocelli. I have just let in 2 people who are identified as court reporters. I don't know if you're both here for the 2 o'clock hearing, but let's confirm. I see a Kelly Lawton and a, where'd it go? Jennifer Boudreau.
Yes.
You're both here for the 2 o'clock?
I'm here for the 2 o'clock, Your Honor, yes.
I am as well.
Okay, well, I guess we'll have to let everybody in and figure out who's today. Let me go ahead and let everyone in. Good afternoon, everyone. We still have 1 person connecting to audio. If you could bear with us a moment. And we do have more than 1 court reporter, so I don't know if counsel want to figure out amongst themselves who should stay. I don't know who ordered who.
I don't know either, but Mr. Steins can keep his reporter.
Okay. This is Jennifer Boudreau from U.S. Legal. I was ordered by Basil Bain, so I will log off.
All right, thank you.
Thank you.
So I think we also have a Deborah Lugo. I'm not sure if she's also a court reporter. She's nodding her head yes. All right, Miss Lugo, I don't know how we have so many court reporters today, but I think we've decided, was it that Kelly Lawton's going to be staying on?
I was retained by Mr. Steins.
It's Mr. Stein's motion, right? I see, Mr. Steins, you're muted, but I can see you nodding. Okay. Okay. So,
Your Honor, it's my motion.
all right. So I don't know who retained you, Ms. Lugo, because Mr. Bain said he retained the other one. So we ended up with 3.
Yeah, I'm not sure what happened. Could have been a mistake by my office, but
Your phone is muted, Ms. Lugo. I see you're trying to talk, but if you do *6 on your phone, that should unmute you. There you go.
Is it Sunshine Workforce case?
Sunshine Workforce LLC versus LII Inc.
Okay, I'll let you guys handle it. I'll log off.
Thank you, Ms. Lugo.
Here.
All right, so we are here in 20 CA 98 Sunshine Workforce LLC versus LII Inc. on defendant's motion to compel plaintiff to produce electronically stored information and for sanctions filed April 5th, 2021. The order of referral was April 26, 2021. I wanted to note that this is being live streamed to YouTube in order to maintain public access to the court, so please keep that in mind. I note we have Kelly Lawton as our court reporter today, and she will have the official record of our proceeding. Ms. Lawton, if you could just let me know which company you work for.
Esquire?
And that's out of Tampa?
Yes, ma'am.
All right, thank you. So Ms. Lawton will have the official record of our proceeding today. I will turn it over to defense counsel for argument. I did want to note for the record, I received and reviewed the materials that were provided by Mr. Stein's office, as well as, I think I got 2 separate packages, and I have reviewed them both.
Thank you, Your Honor. Is it possible for me to share my screen? It might help with my arguments if you see what I'm talking about.
Sure, I have to allow that. So hold on just a moment. All right, you should be able to do that now.
Thank you, Your Honor.
Actually, you know what? I never asked for counsel to make your appearances for the record officially now that we're on the record. If I could get appearances from counsel starting with plaintiff.
Good afternoon, Basil Bain of the Bain Law Firm, appearing on behalf of the plaintiff, Sunshine Workforce LLC.
All right, and for the defense?
Your Honor, Robert Steins on behalf of the defense.
All right, thank you. Now go ahead, Mr. Steins.
Thank you, Your Honor. As I've shared my screen, I'm going to go through some emails to help the court understand the issues that I'm presenting today. I do want to start with some background. As the court probably already knows, Sunshine, the plaintiff, is a staffing company. Sunshine has sued my client Likes, which is an insurance agency. The claim is that my client was hired to procure workers' compensation insurance from Sun's insurance company, and which my client did in 2017 and 2018. The plaintiff is alleging that the workers' compensation policy in 2018 was too expensive. They were subject to an audit where it was discovered that there were misclassified workers. That resulted in the classification codes were inaccurate. That resulted in an audit premium. So the premiums and the audit premium increased the cost of the workers' compensation policy. Sunshine alleges that it was too expensive, and that put them out of business in 2019. Through discovery, we have learned that shortly after that 2018 workers' compensation policy was procured, Sunshine went out into the market and looked for other insurance agents to help them procure, a workers' compensation policy with better rates. They fired my client Likes. They hired another insurance agency, in particular one by the name of Scott Ravanesi at Assurance Agency. That's Assurance with the A for the court reporter. We later found out that the corporate rep of Sunshine was owned by two brothers, Stephen Tabarini and Victor Tabarini. Stephen Tabarini's wife formed a competitive staffing company, and Sunshine's workers moved over to Tideline. That was a competitor staffing company. And then the brothers sued each other. Our defense is that it's not our fault that the workers were misclassified. The premiums were accurate based on the accurate classification codes. The company went out of business not because of something Likes did, but because of what was going on inside the company, the mismanagement, the forming of a competitor company, that sort of stuff. So those are some of our defenses. So for the purposes of this case, some of the relevant topics here are workers' compensation insurance for Sunshine, the classification codes of those workers, the audits that were done on Sunshine, and the disputes regarding the audits. Those are some key issues in this case, Your Honor. So in May 1st, 2020, I sent out a request for production to Sunshine. Up on the screen are some of the communications I requested. I requested communications from Sunshine to third parties. I don't know what third parties they spoke to about workers' compensation, but it's my understanding that they did. So I said, I want those communications. I want communications from Mr. Tabarini to anyone regarding the issues in the complaint. I want communications between the brothers regarding the issues in the complaint. I want communications from Sun's Insurance regarding the issues in the complaint. So that was sent out May 1st, 2020. July 2nd, 2020, Sunshine responds. I didn't get any documents, not a problem. July 17th, they respond with 440 pages of PDFs. Now, bear in mind, Your Honor, I requested ESI. I complied with the rules of procedure, and I requested communications as electronically stored information in native or near native format so that I can sort the information, I can see metadata, I can see what's going on with these emails. So I requested it in a specific form. What I got back was PDFs. Okay, I sent an email to Mr. Bain saying, I appreciate the 440 pages of document. I expected more, but I guess there isn't any more. However, I would like them as ESI. I would like to see the metadata. Mr. Bain and I went back and forth on this for several months. Finally, I prepared a motion to compel. And as a professional courtesy, I shared that with Mr. Bain. Here's my motion to compel. Here's what I want. I shared that with him around September 17th, 2020. After he saw my motion to compel, he then decided to, yes, he needs to send me ESI. So he sent me rolling discovery on December 1st, December 30th, and February 15th, 2021. He starts to send me electronically stored information. And not only that, I'm getting more than 440 pages. It's like someone realized there's a whole bunch of information that they haven't given me. Great. So February 15th, 2021, I get their last production. And this is important because I'm supposed to be deposing the corporate rep, Stephen Tabarini, on February 19th, just 4 days after that. However, I rolled the punches. I moved forward with that deposition. In that deposition, I asked Mr. Tabarini, who did you speak to about the workers' compensation issues? In that deposition, he said, within 48 hours of receiving the policy, I reached out to, and he, actually I can show this to you, Your Honor. In his deposition, I asked him, he said he reached out to InSource, Pritchard and Jordan, IOA Insurance of America, Scott Ravanesi at an assurance agency, and Kurt Setzer. This is my question to him, trying to tie up what he told me. Okay. Now, I would have expected to receive communications from these companies, from these individuals. I didn't see much. I did see some emails from Scott Ravanesi. So I trust that Mr. Bain has conferred with his client and told his client he needs to produce these communications. That's my faith in Mr. Bain complying with his ethical obligations. All right, so I guess these emails don't exist. So I move on. Then on February 25th, we deposed the corporate rep of Sons Insurance. His name is Paul Hodges. And at that deposition, Mr. Bain shows an exhibit I have not seen. It wasn't produced in discovery. It's an email. It's an email from Paul Hodges at Sons Insurance to Scott Ravanesi and a number of people. And you can see the email is dated June 8th, 2018. The topic is Sunshine Workforce LLC re-audit due to dispute. This obviously is relevant because Mr. Bain is using it as an exhibit in the deposition, so it's relevant. It hasn't been produced to me. Okay, this is the problem. Now, I looked at Mr. Bain's response, and he says, well, this wasn't responsive to my discovery request because no one from Sunshine is on this email. Well, I beg to differ, because if you look at the top, you will see that someone forwarded this email to Steve Tabarini at Sunshine at some point. I don't know when, but this is a communication that was sent to Steve Tabarini. This is responsive to my request, and obviously it's relevant because he's using it. That's Exhibit D, Your Honor, to the deposition. Then Exhibit E, this is interesting. Exhibit E is an email. It's the same date, June 8th, 2018, from Paul Hodges to Linda. Who is Linda? Linda is an employee at Sunshine. And you will see that Paul says, I do not believe that is an option at this point. What is he talking about? What option? I don't know. Obviously, Linda sent him an email and he's responding, I haven't seen that email. So if you scroll down, you will see that Linda on June 8th, 2018 at 4:45 p.m., she forwards an email to these gentlemen, Steve Tabarini included, Scott Ravanesi, but I don't see the body of the email. I don't know what was forwarded. In fact, I don't know how Linda even got the email to begin with, because I don't have it. I don't have the email. I don't have the electronically stored version of the email. So I scroll on even more. I see Linda is sending an email to Paul, Steve, and Scott, but it jumps to June 11th. So we went from June 8th to June 11th, and this is not in response to the previous emails. So there's emails missing. And what it looks like, because I practice in digital forensics, is that someone forwarded an email, and when you forward an email, you can delete the body of the email, so you can delete content. So if you don't want someone to see what was in the actual email, you can delete certain items and then forward the email. I'm not saying that's what's happened here, but it looks suspicious. And if I had the metadata, I could tell what was going on. So I speak to Mr. Bain about this issue. I say, I think I'm entitled to the ESI here. I still haven't received the ESI. He recommends that I send a subpoena to Assurance. Okay, you know what? I'll do that. So I send a subpoena to Assurance Agency, and yes, sure enough, I get PDFs from Assurance, and there's a whole bunch of other emails I have not seen that are within Sunshine's possession. For example, here's an email from Linda Frost to Scott Ravanesi at Assurance discussing work comp audit. This one is interesting to me because if you scroll down, Scott is telling Linda that clients need to be terminated. That seems important. That might go to why the company went out of business. Clients need to be terminated. You scroll down some more, you will see that Linda says the following clients have been fired. I think that's important because it goes to causation as to why this company went out of business. These are emails between Linda Frost at Sunshine and Scott Ravanesi that were not produced by Sunshine. Okay, I still don't have the metadata for this because Assurance is saying I'm a non-party. I don't need to produce the metadata, but I'm fine with that because obviously it's in Sunshine's possession. So I should see this. Then here's another email, Your Honor, that's even more interesting to me because August 2nd, 2018, Scott Ravanesi sends an email to Victor Tabarini and Linda at Sunshine Workforce. Okay, the insurance agent is sending an email to one of the owners and one of the employees. And in the email, he says, please tell Steve I'll only deal with you two and that's it. He needs to, actually I can't see the rest of this because of my screen. Yes, he needs to get out ASAP before he does any more damage. Whoa, this is important. Why are they saying that Steve is doing damage to the company? This should have been produced. This should have been something I should have seen before Mr. Tabarini's deposition. This would have been an area of inquiry. Someone is saying that Steve is causing damage. But here's what's more interesting. You'll see that this is an email from Scott Ravanesi to Victor Tabarini and Linda. Steve Ravanesi is not included on this email. But if you skip forward to August 6th, Steve Tabarini is sending an email to Scott and Rick where he says, Rick, please call to discuss. If you scroll down, he has possession of the email that Scott sent to Vic and Linda, in which he wasn't included. Okay, how did Steve get this email? Did someone forward it to him? And then did he delete the body? Did he delete the contents of the email so no one would see what they were talking about? This is relevant to the case. I requested this information. It hasn't been produced to me. It hasn't been produced to me at all, and I haven't seen an ESI version of this email. Your Honor, and then finally, before I end my arguments, damages is a big issue in this case. So I requested documents to support their damages. They sent me their profit and loss sheets. Okay. So when I deposed Mr. Tabarini, I asked him questions about the profit and loss sheet. On April 21st, 2021, this is almost 2 months after I deposed Mr. Tabarini, I deposed the bookkeeper for Sunshine. So I deposed her on April 21st. In that deposition, Mr. Bain uses a profit and loss sheet as Plaintiff's Exhibit Comp 1. And you will see, Your Honor, the date on this is April 12th, 2021. So this was printed a week before the deposition. I asked her, when did you prepare this profit and loss sheet? She said she prepared it not too long ago based on Steve Tabarini's request. Okay, why didn't you use the profit and loss sheet that was previously prepared? Well, the ones that were previously prepared, the ones that were produced to me, that I have in my possession, are inaccurate or they're missing information. So this is the most up-to-date profit and loss sheet. So the one they produced to me is not the most up-to-date, is not the most accurate. And that's the one I relied on when I deposed Mr. Tabarini. I'm now being told they created a profit and loss sheet after that deposition that's more updated. Well, why wasn't this document has not been produced to me, and it hasn't been produced with the metadata. So I'll stop sharing, Your Honor. These are the issues, my frustration so far with this case is that emails have not been produced to me. They haven't been produced to me in a ESI form, and I'm being surprised by emails that should have been produced to me last year. So what I'm asking for is, please give me the emails that are responsive to my request for production. At the time, I asked for emails with third parties regarding the allegations in the complaint. I don't know who Sunshine spoke to. I don't know who Mr. Tabarini spoke to. You know who they spoke to. You know who the third parties are. Please give me those emails. After Mr. Tabarini's deposition, we now have a better idea of who he spoke to because he stated them in his deposition. So give me those emails. I shouldn't have to be going out into the world to get these emails when they're in your possession. It's interesting to me that they produce some of Scott Ravenessi's emails, but not others. So someone is either cherry picking emails, or they have decided that, we're not going to produce this because it harms us in some way, or whatever search terms they used didn't pick up these emails. So I want them to use the search terms, use these email addresses to give me the information I requested. And based on the fact that I'm getting emails after the deposition, I'm getting emails that should have been produced last year, I'm requesting, if necessary, a second deposition of the corporate rep to ask about these emails that were not produced before his deposition. And those are my arguments, Your Honor.
Your response.
Excuse me. Yes, Your Honor. And thank you for the opportunity to respond. The first point that I will make that's obvious from a review of the motion that was filed and from the argument of counsel is that his arguments are well beyond what's argued in the motion. And therefore, obviously, that would be inappropriate. And I think any arguments in that regard should be disregarded. Returning to what was actually presented to the court as a motion, and it's a motion to compel, and it refers to certain requests to produce. With respect to that request and with respect to that motion to compel, I would submit to the court that motion, it is not well-founded and it should be denied because it doesn't pertain to any document at issue or a document that was the subject of any proper request. When you look at the motion to compel, you'll see that it refers to two paragraphs of defendant's first request to produce. It refers to a paragraph 65 and a paragraph 66. Paragraph 65 calls for communications to or from Sunshine to any third parties relating to the allegations in the complaint. Paragraph 66 refers to communications to or from Stephen D. Tabarini relating to the allegations in the complaint. The first point, Your Honor, is that these requests obviously are overbroad and they're not specific enough to serve as the basis of any motion to compel. The first point where it's clear that it's overbroad, it's clear that it's overbroad with respect to this reference to just any third parties. And I think that's part of the problem in this case, is that defendants have put forth very broad requests, and then they have tried to use the so-called process of discovery to continually try to expand upon those requests. And I don't think that's appropriate. I think with respect to requests to produce, there is an obligation to have a degree of specificity with respect to what's being requested, and so that the person who's responding to it can appropriately respond. In this case, the requests are overbroad, and we objected on that basis. And if you look at the responses to the request to produce, you'll see that when we responded to the request, we made it very clear that there were issues with the request. We requested to the request to the extent that that they were overbroad in subsection E of the general objections. We objected to the specific items of that request that we thought were overbroad. The items that just referred to relating to the allegations of the complaint. I mean, come on, we all know how to draft requests to produce, and it's obviously overbroad to say, I request any documents, relating to the complaint, or any documents between, third parties relating to the complaint. there's an obligation to be, there is an obligation to be more specific than that, and they were not. And we specifically raised those objections when we responded to the request to produce, and those defects in the request were not corrected. We raised those. They were raised as issues in paragraphs. Objections were raised in paragraphs C, E, F, and G of general objections. And then when we responded to the specific request, if you look at our responses to paragraph 65 and 66 of our response, we made it very clear that we thought that the term third parties, it was not defined, it was broad, it was vague. To the extent that the request was just saying related to the allegations of the complaint, that was overbroad and vague. And there was no attempt made to revise the request and to make it more specific so that a more tailored response might be made. We had the same issue with respect to paragraph 66 of the request, and we raised objections again, and we stated those objections. But despite those objections, we attempted to make a response to the request, and we made a good faith response. When we initially responded with our document request, as counsel indicated, it was over 400 pages. Not only were there pages and PDFs, there were there was a schedule in a good faith attempt to indicate how the documents that had been produced were responsive to the request that had been made to the best of our ability. That was a clear attempt to comply and a good faith attempt to comply with the request. When we look, so the first point is that the request, particularly paragraphs 65 and 66, are overbroad. Secondly, Your Honor, and perhaps more importantly, the document to which the motion to compel refers, and again, I'm referring to the motion that they filed, not the arguments that have been made by opposing counsel, on the spot here. If you look at those requests, and if you look at the email that's being referred to, the Ravanesi email, you'll see that that email is not responsive to the request, because the request asks for emails between I believe, if you look at the request itself, you'll see that number 65 of the request calls for communications to or from Sunshine, and number 66 of the request calls for communications to or from Stephen D. Tabarini. The Ravanesi email is neither, therefore it's not responsive to those requests. The Ravanesi email, as counsel has indicated, was a communication between Paul Hodges of Sons Insurance Company and these other parties, other people at Sons, Don Craig, and other people that were listed. So it's clear that what the email that is being referred to by counsel that was used in a deposition is not responsive to the request that they're referring to in their motion. So there's no merit to the motion to compel. Despite the fact of the defect of the request, I, as counsel for plaintiff, made a good faith effort to try to resolve the issues that were raised by opposing counsel. If you look at the exhibit to my response to the motion to compel, you'll see I took the time and I prepared a detailed letter to opposing counsel, raising the issues and making an attempt to resolve them. I have not only corresponded with opposing counsel by letter, I've also had more than one telephone conversation with opposing counsel in which I've tried to resolve whatever reasonable requests he might have. But just as it has been demonstrated today, it's a moving target. One argument is made at one point with respect to a request, and then at another point, a second, third, fourth, fifth, sixth argument is made. So the problem with problem with the argument of the defense in this case, and the problem with their discovery position is that it is a changing target, and the problem with that identifies and highlights the importance of requests for discovery being specific enough so that when someone responds to it, they can respond to it appropriately, and when the court looks at the request, looks at the response, it can make a determination as to whether the issue is something that is responsive or not. And in this case, Your Honor, I think it's clear that the arguments that made in the motion to compel, the document that is referred to therein, is not something that would be responsive to paragraph 65 or 66. Moreover, Your Honor, there's been this discussion about the Ravenesi email. Counsel has indicated that he has requested documents from the employer of Mr. Ravenesi, Assurance, and we did not, as plaintiffs, we did not object to that request. We don't have any issue or problem with responding to appropriate requests for discovery, and we don't have a problem with defense getting those from us or getting those from someone else. We did not object to the document request to Assurance. And it's my understanding that the defense has obtained responses to that request to Assurance. And I assume that some of the documents that we've seen today are documents that they received in response to that third-party request. Now, even though we, under the rules, requested copies of those documents, even today, and even though those documents have been used in depositions and are being used in argument today, even though they're not part of the motion, plaintiff still hasn't gotten copies of those documents that have been apparently received by the defense. So the other important point I think to make here is this is a case about whether or not appropriate discovery requests have been made. This is not a question about whether or not plaintiff has responded and provided electronically stored information. There's no question that we have. We provided initially over 400 documents. We provided subsequently thousands of documents thereafter. And that has been done despite the fact that the requests that have been made are in great degree defective. So our position is, Your Honor, is that the motion to compel, even if you just look at the face of it and you read what's being requested, if you read what is in that motion as to what the issues are, I think it's clear that the motion to compel has no basis. There's certainly no basis for any type of sanction, no basis for an attempt to try to retake a deposition in this case. And quite frankly, Your Honor, we believe that based upon Florida Rule of Civil Procedure 1.380, plaintiffs are entitled to recover the expenses that have been incurred with respect to responding to this motion.
Okay, any rebuttal?
Very briefly, Your Honor, I just want to point out that Mr. Bain says that our request is overbroad because we mentioned third parties. I've discussed this with him. I don't know who his client spoke to. His client knows who he spoke to. That's why it says third parties. At Mr. Tabarini's deposition, he outlined the third parties. So I had a conversation with Mr. Bain. I said, here are the individuals. Would you agree to produce the emails with these companies and these individuals? He said he'd speak to his client. He has not gotten back to me about that issue. Okay. Then he says this isn't an issue about ESI. The fact is, I have received PDFs. I have not received the emails in native format. This is an issue about ESI. Thirdly, he says that this wasn't a communication with his client. As I pointed out to the court, if you look at the header of that email, you will see that it was forwarded to Steve Tabarini at sunshineworkforce.com. So it is a communication to his client. So it is responsive. That's it, Your Honor.
Okay, so I'm going to go through these issues, hopefully. I'm going to do my best to go through them one by one. So with respect to the argument that there have been, I guess, oral arguments presented today that are beyond the scope of the motion, I believe I am limited to the issues that were raised in the motion and the exhibits attached to the motion. So it looks like from my review of the motion that the only requests specifically identified in the motion were numbers 65 and 66. There was also a specific reference to certain documents identified at the deposition on February 25th, 2021, including an excerpt of one of the emails that's been shown as well today on screen sharing. There's also an allegation that Sunshine still has not supplemented its production to include the additional emails in its possession that it has not produced. So I think those allegations are within the scope of the motion. So to the extent that there are documents responsive to 65 or 66 that have not been produced in ESI, original native ESI format, that they need to be produced. There's been at least one example provided, the one that was cut and paste on page 5 of the motion, that does appear to show an email to Mr. Tabarini, or either to or from Mr. Tabarini at sunshineworkforce.com. Now it's been represented that this email has not been produced. Do you dispute that, Mr. Bain? In ESI format, let me clarify, not been produced in ESI format.
Your Honor, as I read the email and we're talking about it being forwarded, I think the date that's indicated on that forwarding, I think is February 2000. If I look at that, February 2021, which is well beyond the date of any request in this case. But I don't have, and defense doesn't have a problem that with reviewing the documents and seeing whether this particular email between Mr. Hodges and Mr. Ravanesi was forwarded, within the time frame that we're talking about, June of 2018, and producing those documents. But what obviously, as I've indicated before, what we don't want to do is we don't want to have this continual expansion of what is being requested and what we're supposedly trying to respond to.
Okay, well, I'm looking through the request itself, and I don't see any time limitation in the request for when, as long as it was related to the allegations in the complaint, I think it's responsive. And if it was an email to or from your client, and I would note that Sunshine, so there's two different requests. One is Mr. Tabarini specifically, and one of them is Sunshine, which includes its directors, officers, agents, employees, servants, successors or predecessors in interest, representatives, attorneys, investigators, affiliated entities, and any person acting or purporting to act on its behalf. That's the definition that was used in the request. So, to me, I don't care if it was forwarded on February 25th, 2021, or if it was printed on February 25th, 2021. If it was an email between a third party and Sunshine or any of the people identified in that definition, it's responsive and it needs to be produced in electronic format. Now, as I've indicated, I'm only going to consider 65 and 66 because those are the only two that were specifically identified in the motion. I do want to go through the objections that were asserted in response to those two, since this is a motion to compel. I think when you have a motion to compel, the court is obligated to consider the objections that were raised in response to those two requests. So as to 65, the first objection asserted, and I wanted to clarify, there's been no amended response since the response that was attached to the motion as Exhibit B?
I believe that is correct, Your Honor.
Okay, so looking at Exhibit B to the motion, which, as I'm being informed, is the operative response. The first objection is that it's on the basis that the request is overly broad and vague and that the term third parties is not defined. I think third party is a standard, has a plain and ordinary meaning, which is anybody that's not a party to the action, such that it is not vague and overly broad as used in this request. And given that it is limited to the allegations in the complaint, complaint, I find that that should be overruled. Then as to the next objection, as to it being, it says objection is asserted to this request on the bases and to the extent that its language, i.e. relating to, is overbroad and seems to seek documents protected from disclosure by the work product doctrine and the attorney-client privilege. So I guess the objection to the phrase relating to, you're asserting it's overbroad because it could include attorney-client work product. I generally, those are the type of categorical privileges that normally a privilege log is not required, and counsel is usually not even trying to get those types of documents. Mr. Steins, do you have any objection to a categorical exclusion of attorney-client privilege communications and or work product communications?
No objections, Your Honor. I'm not seeking attorney-client privilege or work product.
Okay, so I think that by allowing that categorical exclusion, I think that that satisfies that objection to the extent that it could include correspondence between Sunshine and its attorneys, or maybe consultants or consulting experts and whatnot. And then the response goes on to say, subject to such objections, to the extent non-privileged documents evidencing the referenced allegation exist within plaintiff's custody, possession, or control, plaintiff will produce same to the extent they are not already in defendant's possession, and upon prior agreement that production of same would satisfy this request. I don't think that there's any need to reach an agreement that production would satisfy the request. So I'm going to I don't know that that's an objection, but I don't think that that's required. If you have it in your possession and you need to produce it, I would give you a time period within which you can review your documents again, Mr. Bain, to confirm that you have produced, or your client has produced, all documents responsive to 65, given the court's ruling today as to the scope. And I mean, it is not specifically asserted in here as that the objection is overbroad because it references allegations of the complaint, but I can read through the complaint. The complaint contains the allegations that it contains, and to the extent that these correspondences or communications relate to those allegations, they should be produced. And again, that includes failure to comply with the PSA. I think, do you all agree that failure to comply with the PSA includes the audit that was conducted?
Yes, Your Honor.
Mr. Bain, do you dispute that?
No, Your Honor.
Okay, so any communications relating to the audit need to be produced, and those would be, as to number 65, which is the only one I've gone over so far, that would be any third party and Sunshine. And again, the definition of Sunshine includes employees, officers, etc. I've already read it into the record. All right, number 66 has similar objections. This one does not have the third parties issue. The only objection on this one is as to the relating to language and the failure to specify any particular allegation of the complaint. So this one does include that. Again, the complaint contains the allegations that it contains regarding the failure to comply. They're pretty detailed in paragraph 10 of the complaint. I think that that is sufficient for purposes of responding to the discovery request. And the balance of the response is that documents will be produced except for attorney-client work product. Again, you agree, Mr. Steins, to categorical exclusion of those documents?
Yes, Your Honor.
All right, so I would give you a time period within which to confirm, Mr. Bain, that your client has searched its documents for any emails with Mr. Tabarini, which appears to include the one that was excerpted in the motion, but there could be others. And I guess that's Mr. Stein's concern, is that there needs to be a search to confirm that all responsive documents have actually been produced, and when they are produced, that it's in electronic format. So how much time would you need from an order adopting the report and recommendation to produce those additional documents, Mr. Bain?
Your Honor, I think 20 days will be sufficient.
20 days?
Yes, Your Honor.
Now, to be clear, that's from the order adopting my report. So is there any objection to that, Mr. Steins?
No, Your Honor. I do want to bring up, and I think based on your order, this is a separate issue as to the extent these should have been produced before Mr. Tabarini's deposition. Discovery is now closed. So I guess that might be a separate motion.
I don't believe your current motion raises that issue, and I think it's going to depend upon what's discovered and whether that would, if there are additional documents, whether you have a need for an additional deposition. So to me, that would be more appropriate in a separate motion to compel that.
Okay, thank you, Your Honor. And again, just for the record, when we talk about third parties, I want to make it clear that to Mr. Bain and to the court that in his deposition, he identified specific individuals he spoke to about the issues in the complaint. So for Mr. Bain, to help Mr. Bain with his search, I think his client has identified certain third parties that need to be identified in the search for emails.
Well, and I mean, Mr. Bain, do you want to respond?
Yes, and just for clarity, that's fine. If we have a specific, roadmap as to what to look for, I don't have a problem with that. I guess one of the things I want to make sure I understand the court's ruling on is with respect to the language that says allegations of the complaint. Your ruling is that you will leave it to us. Are we permitted to just look at this paragraph 10, or are you saying that we should just review all of the allegations of the complaint, and to the extent that there is any third party, try to respond with respect to whatever all those allegations might be?
The allegations of the complaint are the allegations of the complaint. I don't think you're limited to paragraph 10. It's the entire complaint and all of the alleged allegations contained therein, which includes paragraph 10, which details paragraph 10A through M of the alleged failures to comply with the PSA, which we've all acknowledged includes the audit that was conducted. And I don't think they have to do a request as to each paragraph of the complaint. I think just by saying, and as to third parties, just to be clear, although there have been some identified in the deposition, I don't think that is an exhaustive list. The deposition that was shown on the screen was just a sampling, I think, and I don't think it was intended to be exhaustive. Yeah. So, yeah. And there was an argument made earlier regarding the search terms that were used, and I don't know what the search terms were. Nobody has presented that to me. If there's a dispute regarding, if you want the court to decide what are appropriate search terms, I'm happy to decide that, but I would need to be presented those, and I would usually entertain both sides saying, I think these are the right search terms, and the other side says, no, these are the right search terms, and then I can make a decision. But y'all know the case much better than I do, so I'm not going to come up with search terms in a vacuum. So I don't have any basis to rule upon specific search terms today, other than to say that the party has a duty to search their own records and respond to discovery in good faith. And if you present a specific issue to me, I will rule upon it, other than just to say that motion is granted. I've overruled certain objections as to 65 and 66. I'm recommending that 20 days from the order adopting to produce any new documents. So you don't have to reproduce what you've already produced, but anything that's been produced that's not an ESI needs to be an ESI to the extent that you have it in ESI. And if there are any new documents that have not been produced, they should be produced within that time period. I think that was everything in this motion. Let me just double check, because I think that would include the specific email that was referenced on page 5, as well as any other emails that Mr. Tabarini received that are related to the complaint allegations. And then as to sanctions, I know there was a request for sanctions as well. And I'm not going to address the second deposition issue today, because I don't think it was really raised in the motion. What, if anything, are you seeking regarding sanctions today, Mr. Steins?
Well, I was seeking, I could move for attorney's fees. Obviously, that's on the table. So I would seek my attorney's fees for preparing the motion and dealing with this issue. In the alternative, I wanted to reopen discovery on some of these issues. But I guess they're saying that's not before the court as to reopening discovery. So it would be the attorney's fees for filing this motion.
Okay, your response to that, Mr. Bain?
Your Honor, I don't believe in the motion to compel that there was a request for attorney's fees. I think the only argument that was made, I think, was the attachment of a case that was seeking, dismissal of the complaint. So I would, obviously, I don't think that's an appropriate response, and I don't think a request for fees has been had been made by the defense, even though they were made by plaintiffs.
Any rebuttal?
Your Honor, to the extent that I cited the rule 1.380 that says you can get attorney's fees, and in there I did say, if you look at my motion, page 5, I guess this would be right under request to compel and to sanction. I have, if the motion is granted and after opportunity for hearing, the court shall require the party whose conduct necessitated the motion or the party or counsel advising the conduct to pay the moving party the reasonable expenses incurred in obtaining the order that may include attorney's fees. So it's in there, Your Honor.
Okay, yeah, the rule on attorney's fees, which is 1.380, trying to remember. So I thought this has numbers, but I thought it was letters. But in any event, the rule requires that if a motion is granted, the court shall award attorney's fees unless you fail to certify in good faith that a good faith effort was made, or the opposition was substantially justified, or an award of expenses would be unjust, is the wording I'm used to. And that's actually 1.380A4. So I think your motion's missing the subsection A, but I think we're all on notice as to what that rule says by, looking at the rule itself. I'm going to reserve ruling on attorney's fees, assuming that the defendant provides their additional production within the time period that I've recommended today. I would not be inclined to grant attorney's fees, given that there were objections asserted to the scope of the request. There was some production of ESI since the motion was filed, and then so I will reserve, but that may be renewed if the defendant fails to comply with what I've recommended today.
You mean the plaintiff, Your Honor?
I'm sorry. Yeah, the back. Yeah, switch that around. I'm sorry. Yeah. So the plaintiff is the one who was opposing the motion today. So assuming the plaintiff complies with what I recommended today, then I would not be inclined to award attorney's fees. Okay, but I will reserve on it to allow it to be renewed if they fail to comply with the recommendation I'm making today.
Thank you, Your Honor.
Okay, so Mr. Stein, this was your motion and I did grant it. So I'm going to ask you to send in a proposed report and recommendation that sets forth my findings as I've announced it on the record today. I have a template report and recommendation for civil cases that's available on the Magistrate Downloads webpage on the 20th Circuit's website. Just as you would submit a proposed order to Judge Kyle, I ask that you submit a proposed report and recommendation to my office to assist me in getting this moved in a timely fashion. Please circulate that to Mr. Bain before submitting it to my office. I can accept it either by email with a Word attachment to my assistant, or you can upload it to the portal with a cover letter under my name and not Judge Kyle's name, so that it's routed to me. If you have any questions about that, there's a handout at the same Magistrate Downloads page on how to submit reports and recommendations. You can also call my assistant and she can help you. There's a 10-day exception period that applies to my recommendations unless waived. I ask at the end of hearings whether you want to preserve or waive so that the minutes can reflect it. Do you want to preserve or waive, Mr. Bain?
I will reserve, Your Honor, on behalf of the plaintiff.
Understood. I'll note that it's preserved. If you are able to reach an agreement as to the wording of the report, and in that event are willing to waive, and you don't want me to make any changes to it, please let me know that in the cover letter or cover email so that I don't make changes, because I do reserve the right to make changes, especially if you do not waive the exception period, because it might go before the judge, and I want to make sure that the judge understands the reasoning and the analysis that went into my findings and recommendations. Okay. Any questions or clarifications while we're still together today?
No, Your Honor, thank you.
No, Your Honor, thank you very much.
All right, I hope you all have a wonderful afternoon. You're welcome to leave the meeting and I will stay on for my 3 o'clock. Thank you.
Thank you, Your Honor.
Thank you.
Take care. Bye-bye. All right, so we are a little early for 3. I'm gonna take a quick restroom break and I will be back.
Okay.
From the waiting room. We're here, I believe, in 20 CA 359 Fogarty versus Gulf Care Inc. on a motion to compel better responses to interrogatories and requests for production filed April 14, 2021. The order of referral is May 25th, 2021. I'd like to get appearances from counsel, please, starting with plaintiff.
Good afternoon, Judge. This is Attorney Damian Millard, and it's a pleasure to meet you. And I represent the plaintiff.
All right, thank you. And for the defense?
Good afternoon. This is Tatum Brown on behalf of the defense.
Okay, Ms. Hickson, are you early for another hearing?
I am.
I can put you back in the waiting room until we're ready.
Okay, that'd be great. Thank you.
Okay, was anybody expecting a court reporter? Because I don't have one as of now.
I don't think so, Judge, because most of this hearing has been resolved.
Great. Well, I will note that we have electronic court reporting as the official record of our proceedings today. I also wanted to point out that this is being live streamed to YouTube in order to maintain public access to the court, so please keep that in mind. I will turn it over to plaintiff's counsel to let me know what, if anything, is still at issue.
Sure, Your Honor. This is Damian Millard. I represent the plaintiffs. This is a nursing home case, okay? We sent a set of interrogatories and requests for production to the defendant. We filed a motion to compel better answers, and then last night we got better answers to the entirety of the request for production. The answers had basically all been that they will be provided, and the response we got today was, all right, here they are in a Dropbox link. So the entire request for production has been resolved. As of, I think it's 6 o'clock last night, they sent me that stuff, all right? Okay. On the interrogatories this morning, last night again, they sent me better answers to all of the interrogatories. I had moved to compel better answers to 3, 7, 14, 15, and 16. They sent me better answers to all of them except for number 7. I sent Ms. Brown a notification that, I would love to not have to waste the judge's time. Can you please send me the better answer to number 7? The answer that I got at 10 o'clock this morning is still not sufficient. And here's the issue. It's the only one left, Judge, is interrogatory number 7. Basically, what we asked for, it's the standard question I'm sure you've seen in personal injury cases where we ask the names and addresses of the persons who are known or believed by you, your agents or attorneys, to have knowledge of any of the issues in the lawsuit and the subject matter about which they have knowledge. In every nursing home case, and I've done them for 30 years, Judge, what I get is I get an answer that says, the administrator so-and-so knows about liability, Nurse Jones was the nurse and she knows about liability, and CNA so-and-so knows about this, okay? What I got instead was a paragraph that basically says, go look at the whole nursing home chart and figure it out, okay? Now, Judge, I shouldn't have to go and take 30 depositions to figure out who the people are that actually have the knowledge, okay? All that has to happen, and what happens in every nursing home case that I've ever defended or prosecuted, was I call my client and I say, all right, who are the, the 2 or 3 people that have the knowledge of this person and what happened to them? And then I would list them in the answer to the interrogatory. So the answer that says basically, go read the whole nursing home chart and figure it out is just not sufficient. All that I'm asking, Your Honor, is that they tell me who it is that would have, and I don't need anything detailed, like, Nurse Smith, liability, CNA Jones, liability, whatever. And I can read the answer to you if you'd like, because it literally got sent this morning, so you don't have it yet, but I'll read it to you. It says, subject to, and without waiving the above stated objections with regard to the identification of individuals who are believed or known to have any knowledge concerning any issues in this lawsuit, plaintiff shares the same burden of deriving or ascertaining the answer under Rule 1.340C. However, a plaintiff is trying to shift said burden by essentially requesting the defendant perform a detailed review of 3 shifts a day throughout the entire facility chart, where the facility chart and other requested information are equally accessible to both parties and/or can be obtained on an ongoing basis through traditional discovery without improperly requiring defendant to compile all of this information under oath in response to an interrogatory. It says, without waiving the stated objections, please see the facility chart, our entire employee roster provided in response to request for production. And you know what, Judge? I mean, really, I should not have to guess about who's going to know about the care of my client and go and start just randomly deposing people. I have never seen an answer like this before. All that I'm asking, Judge, is that they do what is the basics. What I've always seen done is you call your nursing home client, you say, right, they say Mrs. Smith had this incident. Who are the people that know about that? And they usually get 2 or 3 names, and then that's who we depose. And that's what I'm asking that the court do, is compel them to give me that information rather than, I mean, I can read a nursing home chart, there's 100 names in there. Am I supposed to go depose 100 people till I get the right one? And that's my request, Judge, and that's the reason we're here. Everything else was provided either last night or this morning. So that's what I'm asking for. Thank you for your time.
Okay, thank you. Response?
Yes, Judge, and I'd like to point out, as opposing counsel has read the entire answer, except for the last sentence that did say, additionally undetermined as discovery has just commenced and investigation is ongoing. And I think the issue that we have in this case, Judge, is that the allegations set forth by plaintiff in the complaint include a myriad of issues about falls, injuries, and a very broad failure to properly document the resident's chart or the condition of the chart. And I think, I think we're only talking about a 2-month residency or a very relatively short residency in this. And I stand by the answer as plaintiff's counsel read to you. I mean, basically, if he has any issues or the same way that we would be able to identify any of the facility staff that have any knowledge or issues pertaining to this lawsuit are contained within that chart. So the same way that we could review the chart and let him know who's involved is the same way that he could review the chart. So, as far as our response, I mean, I would defer to our supplemental answer that we provided, and we'll leave it at that.
So briefly, Judge, I just wanted to say that in nursing homes, you typically have a director of nursing, you have a registered nurse, you have LPNs, and you have CNAs. They can simply ask the director of nursing, who are the people that took care of this person? And then provide me those names. We're not asking for a lot. I'm simply asking that they just give me that basic information so that I can take appropriate depositions rather than wasting a lot of time with unnecessary work. Thank you.
Okay. I think when Mr. Is it Millard?
It's Millard, Your Honor.
Was the amended answer? Were there objections before the answer you read? Because it said not.
The original answer, Judge, which is in the court file, I didn't read. I can read that for you if you'd like me to.
I have you attached as an exhibit the original answer. I just was.
Yeah, the original answer is in the court file. That's why I didn't read it. The supplemental answer was what was sent to me at 10 o'clock this morning, and that's why I read it, because I don't think you've probably had the chance to see it yet.
Well, they're not even normally filed because it's usually just a notice of service.
Right. So that's why I read it to you, because that was what the additional information was. And, like I said, Judge, I mean, they can simply ask the director of nursing, who are the people that took care of this person?
All right. So what I'm trying to get to is, do I need to rule on any objections that were stated in the original response? Because nobody's really arguing.
I don't believe there are any. No, Judge. I think it's a question of whether or not they're going to make me go and read the whole chart and try and guess as to who to depose or not.
Okay. So the overbroad, ambiguous, and vague objection, that's no longer at issue, Ms. Brown?
No, they're still there, Judge. I mean, if you look at the interrogatory that was provided, the names and addresses. And if you look farther into that objection, we did object to the addresses of these nursing home staff members as their current employees. But also, it's of all persons who are believed or known by us or our agents or our attorneys to have any knowledge concerning any of the issues in the lawsuit, and specify the subject matter about which they have. So, I mean, as far as that goes, as far as the entire residency and any knowledge of any of these issues, I would stand on those objections that it is overly broad, it is ambiguous, and it is vague.
Judge, I would point out this is a standard Supreme Court authorized interrogatory. It's not like I created this. This is a standard interrogatory that the Supreme Court promulgated for negligence cases. So again, I have never not had a nursing home defense attorney not just give me the names of the 3 or 4, whoever it is, people that are the ones that took care of this person and have knowledge of the events. And that's all I'm asking for.
Your Honor, that's asking for it. We're happy to provide the name of the DON and the administrator who can ask all those questions himself to them.
No, Judge, I'm entitled to know who the CNAs and the LPNs were that took care of this person too.
Okay. All right, so as to the objections that are asserted, I'm going to overrule the overbreadth, ambiguous, and vague. I do note that this is a standard interrogatory, and I think it is proper. As to the objection regarding current employees as agents have right to privacy, normally what I see is that it's in care of counsel. Is there any objection to those individuals being identified care of counsel? And then former employees, you would normally have a last known address.
Yes,
That's exactly what I've always seen done, Judge, is that they tell me who the current employees are because clearly under ethics rules, I can't speak to them. And then they tell me who the former employees are because the rules are different. So yes, that's what I would expect.
And for the record, that's already been provided. When we said see the employee roster, that was in the employee roster.
The employee roster has the last known addresses for former employees?
Correct.
Okay.
Well, then I guess I just need to know who the names are on that roster.
To the extent that that's asserted as an objection, I will rule upon it by specifying that current employees are through counsel, former employees, the last known address will be provided. I don't think that's an attorney-client privilege issue, but I do note that that is a confidentiality type issue, and that's the best way to handle it, and that's the way I've ruled on it for years. All right, so without waiving those objections, now this original answer still stands, as I understand it, right? Supplemented with this new answer that was provided today, Ms. Brown?
Yes, Judge.
All right, so you've gone on to say, without waiving those objections, defendant has reason to believe that John Fogarty, that's the plaintiff, right? That's the patient, or that was the...
That's the husband, Your Honor. John Fogarty is the husband.
Is he deceased, or?
No, he is the one bringing the case on behalf of Beth Ann Fogarty, the resident.
The resident is Beth Ann.
Correct, Your Honor.
All right, so this is the power of attorney spouse. All right, other friends and family of Beth Ann Fogarty, do you not have names of these people, Ms. Brown?
Judge, sorry, for the record, it is actually John Fogarty who is the resident and Beth Ann Fogarty is his power.
Yeah, I'm sorry, Your Honor. I said that directly backwards. She's right.
So John Fogarty is the patient, right? And that's represented by Mr. Millard, so I don't think we
Yes,
need...
and Judge, I don't need her to give me the names of the friends and family. I can figure that out on my own.
Okay, and then, so really you're just fighting over the employees of Gulf Care Inc. that may have knowledge, right?
Right, which would be the CNAs, LPNs, RNs, and whoever it was.
Right, all right, I'm gonna save that for last. And then there also says other individuals could include any non-party medical providers or treaters of Ms. Fogarty prior to and subsequent to the alleged incident. Do you take any issue with that, Mr. Millard?
No, Judge, that's really neither here nor there.
Okay, so leaving only the issue of the employees of Gulf Care Inc. As I understand it, based upon what was read into the record, there's been a reference to documents under 1.340C. Now, you can only do that under 1.340C when the burden of ascertaining the answer is equal to both parties. And my concern with relying upon documents in this particular interrogatory is that it is intended to identify those persons who are believed or known by the defendant, its agents or its attorneys, not the plaintiff and its agents and its attorneys. So I do think that the defendant needs to identify the persons who have knowledge concerning any of the issues in the lawsuit, identify the subject matter, that the witness has knowledge. I don't think you can put that on the plaintiff to identify the people, because by definition, the question is asking for the defendant's knowledge and belief. Now, I note there was also a reference to discovery is ongoing and whatnot, but under the rules, you've got to give the answer as to what you have now. So, and as long as it's complete based upon the information that you have when you answer, there is technically no duty to supplement later, but you have to give the information that you do have. So 1.340B says that, an interrogatory otherwise proper is not objectionable merely because an answer to the interrogatory involves an opinion or contention that relates to or calls for a conclusion or asks for information not within the personal knowledge of the party. A party must respond to such an interrogatory by giving the information the party has and the source on which the information is based. So you got to provide what you know. And I think the defendant has a duty to collectively gather the information that it has available to it to identify the persons it believes or knows to have information regarding this case.
Okay.
So
Thank you,
I'm
Honor.
going to grant the motion to compel as to interrogatory number 7, because as I understand it, the rest was rendered moot given
That's correct, Your Honor.
amended answers. So how much time from an order adopting the report would you need to provide that supplemental answer, Ms. Brown?
If we could have maybe 10 days, Judge, because basically we're just going to have to go through the chart and basically find every name that's listed.
That's fine with us, Your Honor.
Well, and again, I'm not going to tell you how to do your job, but your client has a duty to use its information reasonably available to it to answer the question. And whether that's looking at the chart, talking to the employees, I don't know, but it needs to identify the persons that it believes or knows has information. That's the standard in the interrogatory. So my dates are from the order adopting the report and recommendation, because it's not final until it's adopted by the court. So it'll be 10 days from the order adopting to provide a verified amended response to that number 7 only. And then I think that was all that we need to address today. Mr. Millard, I'm going to ask you to send in a proposed report and recommendation that sets forth my findings as I've announced it on the record today. I don't believe you've appeared in front of me before. So there is for your information, there is a template report and recommendation for civil cases that's available on the Magistrate Downloads webpage on the 20th Circuit's website, as well as guidelines on how to submit that to my office. But generally speaking, it is either by email with a Word attachment or through the portal. I need to know that you've circulated it to opposing counsel, whether you all agree upon the form. If you can't agree, I like to know what the disputes are. And then once I receive it, I'll take a look at it. And then if I need to make revisions, I will. I reserve the right to make changes to ensure that it conforms to my findings, but I appreciate having the draft report to assist me in expediting that.
Okay, I appreciate that you anticipated my question about your forms, because although I'm from Fort Myers originally, I don't think I've ever done a magistrate hearing in Fort Myers until today.
Oh, really? Well, I've been presiding for 5.5 years now, so.
Yeah, well, I'm up here in Sarasota, so I spend more time in Charlotte, Sarasota counties. But it's good to hear from somebody. I went to Bishop Verot down there, so it's my old stomping grounds.
I went to Fort Myers High, so
Oh, Green Wave, huh?
In any
All
event,
right, Judge. Thank you for your time.
The question I have for the record is that there is a 10-day exception period that applies unless waived. I just need to know whether it's preserved or waived. Ms. Brown, do you want to preserve? Do you want to waive? What's your preference?
We can waive.
And Mr. Millard, would you want to waive as well?
Absolutely, Your Honor.
Okay, so in that event, if you can reach an agreement as to the wording of the report, I probably won't make any changes to it. And I just wanted to note there's multiple templates there, so please be sure to use the civil template and not guardianship. I think that's pretty obvious, but sometimes people use the wrong one. So I hope you all have a great afternoon. You're welcome to leave the meeting. Thank you.
Thank you for your time, Your Honor.
Take care. Okay, and we are slightly behind schedule, but not too far behind. Good afternoon, everyone. This is Magistrate Bocelli. I have let in everyone who was in the waiting room. I believe we're all here for 21 CA 754 Roman versus Family Security Insurance Company, Inc. on plaintiff's motion to compel deposition, defendant's motion for protective order, and defendant's motion to determine sequence of depositions. The order of referral was May 25th, 2021. I wanted to note that this is being live streamed to YouTube in order to maintain public access to the court, so please keep that in mind. If I could please have appearances from counsel, starting with plaintiff.
Good morning, Your Honor, or excuse me, good afternoon. Kevin Voris of law firm Cohen Law Group on behalf of the plaintiffs.
Thank you.
Good afternoon, Your Honor. This is Danielle Hickson on behalf of the defendant, Family Security Insurance Company.
Was anybody expecting a court reporter today?
No.
No, Your Honor.
All right, well then we'll have electronic court reporting as the official record of our proceeding today. I will turn it over to, well, they were all filed on the same day and they're all kind of related to each other. I'm going to turn it over to plaintiff first because that was the first motion said is the plaintiff's motion. So go ahead.
Thank you, Your Honor. We're here on the plaintiff's motion to compel the deposition of defendant's corporate representative, Defendant also filed motions, as you said, on the same day for protective order and to determine sequence. Actually, Your Honor, the counsel for defendant and I were speaking yesterday to try to resolve this in advance of the hearing. Defendant's counsel actually sent over a proposed agreed order this afternoon that I unfortunately missed until this moment. And I believe that we would be agreeable to the entering of the agreed order. We were able to come to an agreement basically to have plaintiff's depositions take place before defendants and for the deposition of the defendant to take place no later than end of November of this year.
Okay, if y'all have an agreed order as to all the motions, then I will essentially treat it as a cancellation for my purposes, and you can just submit that agreed order to Judge Schenko to enter.
Okay, that sounds good. I appreciate it. Thank you.
Thank you, Your Honor.
The agreement covers all 3 motions?
Yes, I believe so.
Yes.
All right, so you're agreeable to that, Ms. Hickson, right?
I am, Your Honor.
Okay, so thank you for reaching an agreement so that I don't have to do a report and recommendation from the hearing today. And I will note in my notes that it's cancellation. I'm not going to do a report. The clerk's minutes will indicate the same, that you're submitting that agreed order to Judge Schenko. And that will be all for today. I hope you all have a great afternoon and take care.
Thank you.
Thank you.
Thank you, Your Honor.
And that'll be all for us, Ms. Woods. I hope you have a great weekend.
Okay, thank you, Your Honor.